Many accused have taken advantage of this and escaped while they were being produced to the court. From the police van to the court, there are many instances. And I know of a few instances where the person just went to the bathroom from the window, he jumped and ran away. That's another. But even while the handcuffing is concerned, when you try to enter a lift or some place where there is a lot of rush, so therefore you have to strike a balance between handcuffing and escaping of prisoners. So their sort of balance is sought to be struck. Then another thing that this law does is the old 167 with the new 187. Many a times the earlier law mandated, which has now been doubted in Senthil Balaji, whether the 15 days remand has to be the first 15 days or not. Or it can be anywhere between the first 60 days or 90 days as the case may be. But the new law rectifies this problem. And this required a rectification. You can't, supposing the police want an accused at a later stage where they get new material in the same case, and they want the custodial interrogation, it's not permitted because of CBI versus Anupam Kulkarni. It says first 15 days. There's no logic accepting that the literal interpretation of the law. The law, if you really want to render justice, should be that when you require an accused, the police remand should be granted. Not because in the first 15 days, even if the requirement is after 16th day, you don't get a custody. That would result in injustice because you may sometimes require a custody of an accused after 15 days. So the new law says it is 60 days, the period of remand for the default bail, that is 7 years, etc. You get it for 40 days. Within 40 days, you can ask for that 15 days period will be anywhere between those 40 days. And in the other case, it will be anywhere between those 60 days. So this is a welcome provision. The lawyers for the accused may not agree. But in order to find out the culprit, get evidence, this provision was necessary. Then there is another provision which was there. That provision is regarding house arrest. Can a person be put under house arrest? Of course, constitutional courts have been doing it because there are no fetters on constitutional powers of the court. But as far as the magistrate is concerned, as far as session judge is concerned, can he say that I'm remanding you to judicial custody? Police custody, there's no question of home stay or home arrest. But judicial custody, can it be home arrest? In Navlakha's case, the Supreme Court granted home arrest. But that is because the Supreme Court is Supreme Court. It is not bound by the ordinary criminal law. But the issue still was whether a person can be put behind